Welcome to the best of the best, brought to you by Biles Wilson, a boutique commercial litigation firm based here in the Dallas area, but with a national scope. And this is
Jeremy Wilson.
Dunham Biles. And we're lucky today to be joined by our good friend, mediator extraordinaire, John Shipp. Welcome to the show, John.
Thank you. Appreciate it. Thanks for having me.
Thanks for being with us. So, John, I think you're native of Waco. Is that right?
I am. Grew up there. My family's been there for about 100 years, and most of them are still there.
Yeah. So did you end up going to school there?
One of the things that I've been trying to impress on my daughter is that there's a universe outside of Waco, Texas, or Dallas, Texas, for her, where she's grown up. Mm-hmm. But yeah, no, I had not really envisioned anything outside of going to Baylor University, and I was a Baylor Bear since the time I was 5, and so most of my family went there. My grandfathers, and I say plural, my grandfathers were roommates together at Baylor in the 20s at Brooks Dorm. So my wife went there, my dad went there, my brother went there, my aunts and uncles went there, my cousins went there. So long history of Baylor, but after college, I think I was finally ready to get out of Waco, Texas, if you can believe it.
Yes. So then you went to the big West Texas city, right?
Yeah, I tried to find the biggest city that I could, and I went to Lubbock, Texas, and went to law school. My mentor was a legendary professor at Baylor University named Matt Dawson, and I didn't realize until later that his nickname was Mad Dog, and I always just thought he was the kindly old man, but he really wanted me to go to Tech. I was looking at maybe going to SMU, and he lied to me and told me they were about to lose their accreditation, which wasn't true, but he really wanted me to go to Tech, where his protege, Frank Newton, had taken the job, and so it was a great experience and enjoyed doing that. Then went back to Waco for a year and clerked for a judge. And wrote opinions under my pseudonym, Judge Bobby Cummings.
Excellent.
And great experience also, and probably the best job I've had, legal job I've had, lowest paying legal job I've had, but probably the best job I've had, short of me working for myself and what I'm doing now. It was just a great experience, and everybody was very collaborative when I was there. And then I've been up here in Dallas ever since.
The court you worked for, that was a Court of Appeals, right?
Yeah, 10th Court of Appeals. And so it was Bob Thomas, Bill Vance, and Bobby Cummings. Yeah. And it was, like I said, it was a great experience because everybody got along, and we'd have these meetings, and if there was any, when you talk about dissents and who was going to write the majority, it was simply just. And I know you worked for a federal judge.
I did. Yeah.
Yeah. Maybe not as high profile as the kind of stuff you did, but it was one of those things where Bill, you write the dissent, and I'll write the majority, and so it was just a great experience.
I found it was really good to be able to see things from that side of the bench and just kind of get to watch lawyers for a couple of years and then hear how the judges think. Like you said, it was a district court level for me. With the appellate court level, probably deciding a lot of more policy issues, and I would imagine a little more. Get to see some of those debates with those judges. It had to have been kind of really interesting.
It was, and like I said, I think all of them were very smart. All of them were talented in their own way, and each of them kind of served a role on the court. My judge, I thought, was kind of the heart of the court. Bill Vance was the brains of the court, and not that they were all smart, but he was very kind of intellectual. Like I had interviewed for him, and he had asked me what my favorite Supreme Court opinion was and why, and I think I went home to my parents' house and crawled in the fetal position because it went so poorly. He didn't hire me, but Judge Cummings took mercy, showed mercy on me and hired me. But the irony is that Bob Thomas was the body, was the one that kept everybody together, and it was ironic. Because if you knew anything about Bob Thomas, is that he got polio when he was 13, and he could only move his head and his left arm, and he was in a wheelchair. And so I think my judge and some of their friends would roll him into the elevator and hit all the buttons at Baylor and leave him in there. But
Good friends there.
Yeah, but he graduated #1 in his law class. He was a state senator. He was a district court judge and then the chief justice. And he was the one that kept everybody together. And every time I would feel sorry for myself or, for something, I would think of Bob Thomas because he would always have a smile on his face, despite his physical limitations of not being able to, engage in, physical activity or walk for that matter. But
Yeah.
just a fantastic guy.
So, did you have lawyers in your family, or why did you decide to become a lawyer?
Well, that's a good question. The family business is medicine, and so my dad is a retired internist. My grandfather was a retired he's passed now, but he was a family doctor. My great grandfather was a doctor, and all their wives were nurses. And then I have an 86-year-old uncle who's a cardiologist at the Mayo Clinic. And my parents, in all seriousness, told me that I could be anything I wanted in life except a lawyer. So part of what I decided was that I picked a career based on spiting my parents at a certain level. But the other thing is I saw how hard my dad worked, and he worked 15, 18 hours a day, 6, 7 days a week. And I said, I just don't want to have that lifestyle. So I went to law school, and now I work 15, 18 hours a day.
I was going to say,
7 days a
I'm
week.
not sure about your career choice.
Yeah, so it's some of it may be just kind of personality and genetics and so forth, but I think I'm somewhat of a workaholic too. But yeah, that's how I kind of got to the legal world, and it was something that intrigued me, and I like the idea of being able to get up in a courtroom, and I realized that there wasn't that many opportunities to do that even back then, and solving problems and helping people, and that was one of the main reasons that I wanted to go to law school.
So I think you had a pretty diversified practice compared to others when you started in Dallas. Just
Yep.
everything from negotiating contracts for shows.
Yeah, no, I mean, I did a little bit of everything, none of it particularly well, but I did it. And I mean, I knew that I wanted to do this, very early in my career. And so I just kind of considered it would just be, knowledge that I could bank for later and help with issue spotting and things like that. But as a lawyer, I did everything from negotiate a reality TV series to repossess a 737. And I learned you don't just get in it and
Slide off.
and fly it off. In my case, you had to go to Judge Ferguson, who's a fantastic judge and now arbitrator and friend, to say give me my plane or give me my client's plane. But did business commercial work, did work for a client that was self-insured, which was Whataburger, and we did all their work. And I kind of a esoteric area of law, but at one point in time I had some experience or expertise, I guess that's in the eye of the beholder, but in funeral home and cemetery law.
Oh.
And so I'd represented at the time, I think, the second largest funeral services company in the country that was a $1 billion company and publicly traded and didn't have an in-house counsel at the time.
Wow.
And so,
Kept you busy for sure then.
yeah, so the gentleman that started it relied on his local attorney. He was fantastic, but he would kind of dole out the work in other states to everybody.
Yeah, we want to talk a little bit in a minute, because you're obviously doing mediation full-time now, but, it occurs to me that, during your legal career, you probably did a number of mediations, and I was curious, give us the idea of your perspective of mediation at that point before you kind of really went into it, or.
Yeah, well, I mean, I think that's a good question. I mean, my perspective, and I guess I forgot, I also did some transactional work and leasing for CBRE and Trammell Crow and things like that. But yeah, going to some of these mediations, my sense of these mediations was kind of, I think, the sense that people have now when they come to mediation is that, the mediator comes in and, I think people see me and they see me come in and crack a couple jokes and drink some coffee and tell them their case sucks, and they think, oh, that moron can do that, I can do that. And so, when you're sitting in a room and your input is nothing other than just sitting in an empty room, with your client and waiting on the mediator, you're assuming it feels like nothing is going on. There's obviously a lot going, or should be a lot going on outside of that room, but when you're in there, your inputs are just, oh, this is just sitting around in a conference room, and there's not much going on. But I'll say even back then, things are a little bit different. I didn't necessarily understand some of the nuances of what was going on with the mediators, which I learned even after I took the training, where I went and observed some of the mediators and would have some misconceptions about what the mediator was doing. And then I thought to myself, oh, wow, if I think that, I can't imagine what the attorneys are thinking when they see some of this stuff. So I try to be transparent about why I'm doing things.
Yeah.
Sure.
So you said early on you decided that you were interested in becoming a mediator. What was it about?
Well, I think a lot of people, and I spend a lot of time educating people, just from the standpoint of doing these mediations, the parties at least, that sometimes, they're not necessarily sophisticated in the sense of being involved in a lot of cases. I mean, I deal with a lot of people that, that are very sophisticated that come into these mediations and done a ton of them. And some of them, that are as sophisticated as their lawyers as far as kind of how the process works and what happens. But for me, I came in thinking everything was very black and white, right and wrong, and then I learned everything was very gray, like my hair, and at the time it was it was dark brown, but it was one of those things where, I came in, reading, To Kill a Mockingbird and watching movies and TV shows about lawyers and thinking about our justice system. And at the end of the day, I believe in our system, but I realized it was something different than what I thought it was. And so you can do everything right. You can be, have a righteous position and still go down to the courthouse and lose. And that's why none of you guys, when I turned to you in mediation and I asked, do you want to guarantee a result for your client? You all run for the hills as quickly as possible.
That's true. Absolutely.
Yeah, I mean, no one that's done this should ever do that, but that practice law. But and I feel comfortable asking those questions of you two guys, because I know you'd never guarantee a result. But that's probably a lawyer that somebody needs to run away from.
Exactly, for sure they do.
Yeah.
Let's talk about. You said a minute ago that some of the secrets of mediation, things you didn't know, were revealed in training, and now you're participating. But I think it's also true that you can help others understand that those same issues, because I assume you have a view that people have a misconception about what your role is and what you can do versus what it is that you're truly doing. So can you help educate people a little bit about what it is you really do as opposed to what they think it is that you're doing?
Yeah, I mean, I think sometimes people think that I am. I think there's a misconception, and I think people are sometimes shocked to hear this, where I tell people my job is not to settle your case, and their immediate response, even if it's not verbal, the nonverbal response is, why the heck did we hire you then? What is it you do here? And so from the standpoint, it was kind of beaten into me at a young age from a mediation standpoint, that mediators don't settle cases, parties settle cases, and so from the standpoint of what I do is I help explore and help the parties see what all the universe of opportunities are that are available to resolve a case, and then what I do is I help them make good decisions about whether or not they should engage in some of those alternatives or some of those options. And I will say not every case should settle. I mean, there are some cases where you need to go try it, but that's a very small amount. I mean, if we're looking at the statistics, it's what is it, 3%?
Yep.
Yeah.
I was thinking about this the other day. Is that my entire basis of my practice is called alternative dispute resolution. But if you think about this, if only 3% of cases are getting tried, and 97% are doing something else, and probably the vast majority of them are probably getting resolved in mediation, then the question is, what is the real alternative dispute? Is it? It sounds like it might be trial, because it's only 3%. Sure. But Ann, the thing too that I find kind of exciting about this that people don't really think about is this practice is only about, I checked this, when the statute came out, it was 1987 was the Texas ADR statute. Mm-hmm. So it's only about, if I'm doing my math right, 37 years old.
Yeah.
And even then, during the first couple of years, they weren't really sending cases to mediation. But it's a different animal and continues to evolve and be a different kind of process than what it was maybe when I started.
Yeah, well, I think you started doing this full-time in 2013.
I
is that
did.
right? Yeah, and then, obviously you'd mediated some cases before that. So what are some of the changes you've seen over the time that you've been either as a participant in a mediation or a mediator, and how mediation process or approach to it?
Well, that's a good that's a really good question, and it's a little bit like people go to mediation every however it is as lawyers every week, every month, and even the mediators I don't think necessarily see all the changes that have gone on. One of the ones it's like that boiled frog analogy where the water just keeps getting hotter, but one of the main things, and I hadn't thought about this in a while, but when I first took the training, there was this big debate between facilitative versus evaluative mediation. And at the time, facilitative mediation was kind of the gold standard. And you just kind of lived in the question, and you kind of facilitated an environment in order to help people get a result. And I had to get an hour of CLE recently, and I give a lot of speeches and presentations. And I clicked, I needed 1 hour of ethics. I literally had like 90 hours. And this is for the Texas Bar College. If you have so many hours, you can join the Texas Bar College, which gives you access to CLE materials and those kind of things. So I needed 1 hour of ethics, which, like I said, is the bane of everybody's existence. So I click on the ethics and mediation, was immediately annoyed with the bar and then with myself for realizing there was a 25-year-old presentation. And so I said, well, I'm going to watch it anyway. And what was interesting is one of the questions that was asked, and some of these people on this panel were on, my mentors and people that are still around that I respect. And the question was, is it ethical for a mediator to evaluate a case? And the answer 25 years ago would be, you'd be taking away my bar card right now. It was unethical to evaluate a case. And in these days, that's one of the main reasons people come and see me and guys like me, gals like, guys and gals that do the same thing I do, is to help evaluate risk and help evaluate an issue spot. And that's one of the, my background of doing a lot of different things in the law has helped me kind of issue spot, I think, pretty well as far as find things that maybe if you just are in one little area, you might know how to, you might not pick it up, but because I've been in a lot of different areas, like I said, not very well, but at least been able to issue spot, that helps. But that's one of the bigger things, I think, is the evaluation part of it. I think also kind of the process, you're seeing different kind of things. It used to be that you always did what was, as we all know, is a joint session where everybody comes into a room and each side gives a spiel to the other side about how they see things, and they've fallen out of favor. You really don't do them very much anymore. And the part of the reason why that is because we were trained as mediators that you should always do them. And they would cite these studies that no one could actually show me, what they were, but allegedly you got a better deal if you did these sessions. I think they're great, but they have to be, number one, they're not appropriate for every case, and not every attorney or party is going to be able to execute on it in a way that's effective. And so what happened is the mediators would try to shoehorn these joint sessions into every single case, and then the attorneys started pushing back to the point where, there's certain things like my mom used to make feed me Spam when I was growing up. I can't eat Spam now because I'd eat Spam all the time when I was a kid.
Yeah.
And it's a little bit like joint sessions. They don't want a joint session just because it just has such a negative connotation for them. And the real issue and the real takeaway of that is we were doing that because that's the way we've always done it. And that's not a good reason.
Yeah.
And so we really should be looking at things, and I'm continuing to try to do things like that. Why are we doing this? Is there a better way to do it? Is there a more efficient way to do it? And so, like I said, I think joint sessions are great, but it's been a missed opportunity for everybody kind of pushing everybody into that thing because, like I said, they're not going to be right for every case.
Do you have a default you kind of start with and then let the lawyers tell you what they want, or how do you where do you start when you're initially with a case? Do you start with, I'm just not going to do one now, or do you kind of?
We start with not doing one, and actually I send out an email reminder the day before mediation that says a few things that, this is going to confirm that we're not going to start doing one, but I reserve the right to make everybody go in a room and stare at each other if I
I think it's helpful.
Yeah, I think it's going to be helpful. But, and the reason why I do that is sometimes there's some gamesmanship going on. And sometimes somebody shows up with a PowerPoint and they demand to do a joint session. And the other side has no clue that we are going to do a joint session or that the other side wants to do a joint session. And this, by the way, is what I call mediating the mediation.
Yeah.
And I've got better things to do, and the parties have better things to do, and that's not what you've hired me to do, is to mediate the form of the mediation. And so I tell people, I said, if you want to do a joint session, you need to have a conversation with the other side ahead of time and tell them you're doing it. One of the main reasons you do that is it makes the other lawyer look bad.
Sure.
And maybe that's the goal.
The goal.
And so the other lawyer looks flat-footed when they come in and they don't have a presentation. There's no reason for them to think they should have a presentation. They would have prepared one if they'd known.
Yeah.
But when you lay behind the log and do that, that's not effective. But and then I've had people do joint sessions and put on PowerPoint presentations that is literally their trial presentation, and they don't even change it for mediation. Yeah. Mm-hmm. And and it's like a fraud case. And it's like a 8-figure oil and gas case, and it's like they're going through their slides, and Bill is the defendant, and it's like, Bill, can you see this slide? This is one where you're a crook. Can you see that one? Here's one you're a thief.
But they've already gone to all the work to put this thing together. They've got to use it. Yeah.
Well, right.
I feel like they do, I guess.
And if I don't let them put on their PowerPoint, then they don't get to charge their client, and they're mad at me.
Yeah.
And so there are all kinds of other dynamics that come into play with those kind of things. So I tell people up front, I said, if you want to talk, I think they're great, but at least have a conversation ahead of time. And then if we still have an argument about it, then I'll get involved. And typically what I'll tell the other side is say, look, if they want to put on their dog and pony show, let them. Mm-hmm. And you may learn something, and all you have to say is thank you, and we're here to work.
Sure.
And go from there.
John, one of the other things I want to talk to you about that certainly has been a big change since 2020. COVID's changed a lot of things, and it's changed a lot of things in law. But you're in the forefront of it here in Dallas, which is that we now have remote mediations. Talk to us about how that came, because it had been a threat to your very existence that you couldn't meet people in person. So just talk to us about how that came to be and what it looks like today, and whether it's better, worse, what have you.
Yeah, no, I mean that's a question I've been asked a few times. When they shut things down and the CDC said no parties of 10 or more, all I heard was don't go to mediation. Mm-hmm. And because the entire basis of my practice is having people in conference rooms, and in the I guess the 20 years prior in my practice, maybe I could count on a handful maybe on one or maybe two hands, the number of people that might have shown up on a Skype call or FaceTime. Sure. But it was never like everybody showing up on video. And if you'd asked me before COVID whether or not that would work, I would say there's no way. This is not going to happen. And so when that came down, I had about a 15-hour period where I thought, well, my career is over. I'm not going to be making any money, and I'm not going to be able to make a living. And then I quit feeling sorry for myself, and then I started kind of researching what the options were. Mm-hmm. And I thought to myself, I've got to recreate, the same kind of process virtually that we do in person. And I remember calling, customer support for Zoom, and it was late at night, and I got a customer support person in Australia, so it was the middle of the day there. Mm-hmm. And I said, look, I said, here's what I need to do is I've got to figure out how to, here's what's happened with COVID, and I've got to figure out how to create replicate the in-person process where I have separate conference rooms, or I have separate what I call caucus rooms or breakout rooms where I put the parties, and then I'm able to go from room to room and keep them separate, not have them in the same room, and also be able to bring them into the same room if I need to, but be able to separate them and be able to move back and forth and do this. and I need to be able to move people around. I need to be able to move around myself and to be able to simulate as much as possible doing this in person. And I said, I don't think this is something that, you know, you can help me with, but I just figured I would at least give it a shot and see. And she says, yeah, I mean, the Zoom platform does all of that. And I said, well, great. I said, well, and then I was waiting for the punchline. I said, well, how much is this going to cost me? Because I was thinking it was going to be thousands of dollars. And she says, $15 a month.
You're like, I'm in business again.
Yeah, I'm in
We're back.
business.
They really were in the right place at the right time.
They really were. They really were just perfectly placed. But I will also say, you know, the platform has improved and changed since then. But at the time, I mean, no one knew how to do any of these things. And so a lot of people kind of thought, okay, well, we'll just take a break for a couple weeks until this blows over. Didn't blow over in a couple weeks. Yep. But myself and John DeGroat, and then we brought Chris Nolland in, you know, one of our colleagues, we were working literally 15, 18 hours a day trying. I mean, now it seems simple, but at the time, no one knew how to do it, and the platform was a little bit different, is trying to figure out how to replicate and simulate a mediation. And we were practicing on each other, and, you know, it would be late at night, and Chris would be eating a salad, and it'd be online, and I'd be blind in my right eye, and those kind of things. But we finally figured it out and said, okay, we think we can make this work. Now we've got to get everybody to buy into it. Yep. And so I said, let's give a webinar to the Dallas Bar Association and say, hey, we're back in business. Yep. You know, this is how we can do it. And at the time, at least, it was the most well-attended webinar in Dallas Bar history, because everybody's sitting in their underwear because they can't go to work.
They need something to do too.
But John, is there any indication yet as to maybe, obviously a good thing about this is it makes it easier to get people to a mediation, because you can have a mediation where parties are all over the place. They don't all have to come to the same place. But is there an indication about which cases are still better off to be in-person mediation, or which ones you are better off being Zoom?
Yeah. I mean, that's one of the most common questions I get with attorneys, and sometimes the mediation part of things, where one side is insisting everybody be in person, the other side insists
litigators would do that
by Zoom. Yeah,
strange.
And so myself and you know, the aforementioned John DeGroat and Chris Nolland and Ross Stoddard, we all sat down. This is probably a year ago, when we had probably, you know, I've done several hundred since then, but at the time we'd probably collectively had done about 2,500 of them. And all of us agreed that there was not one case where we thought we would have a different result if we'd done it in person.
Wow.
Yeah. And people are sometimes shocked to hear that. I'm kind of shocked to hear that. I think people thought I was lying when I told them this, because they thought, well, you just can't go into the office and work, and that's why you're selling this Zoom thing. But it truly is, you know, it truly is something that I think is just as effective. Literally have noticed no difference whatsoever. In some respects, it's even better. So from the standpoint, if I'm trying to read you, or I'm trying to read you and I'm trying to read your body language, and I speak two languages, I speak English and I speak mediation, and some of it's nonverbal, some of it's verbal about the words you say. We're not going to do that right now. Means you might do it later. You're not going to do it right now. Yeah. Those kind of things. But if I'm invading your personal space, if I'm like this far from you, but if you have a computer screen and you're this far apart, I mean, I can read every little detail. And then I've had some people say, well, you can't see their legs. If I'm looking under the table, I'm probably doing it wrong in the context of mediation. So I think I haven't noticed that there's any one particular class of cases that would be better in person. I have attorneys that still think that it's, even with this being my life's work and me telling them that they just think that it's better to do it in person. And that's fine. I'm happy if they want to do it in person, we can do it in person. But I think one of the main issues, I think, is they think that people aren't taking it seriously.
Sure.
Yeah.
And the reality is, I have found, ironically, is that sometimes when people come in person, they are too busy looking at their watch, going, I've got a soccer game I got to get to. I've got I got to get across town. I got a flight. Yeah. You know, they have to leave early, right at the critical moment. And of course, they wait to tell me this until about an hour before they have to leave.
Sure. I
So
wondered
that-
that.
oh, go ahead.
I was going to say, I've wondered that because there's a lot of downtime in mediation where you're in between. And actually on a Zoom, you can do things in between while you're waiting. And so people don't feel like they're stuck there. You know, they can be in their home, they can be in their office, they can be somewhere where they're maybe more comfortable than a mediator's office. So I wondered if that was a positive attribute of this.
Well, I'm glad you said that, because you said comfortable, and this is the thing I'm working on right now, is about decision making and how we make decisions, and how do we make good decisions? How do we make sure we're not making bad decisions? And one of the things that I think is about mediation, I think, and this goes to how things have changed, is traditionally people have kind of felt like you're not, kind of like being Roman Catholic or German and English heritage like me. You don't feel like you're doing it right unless you're suffering. and that's kind of how people have felt about mediation, is that you have to be there till midnight or 2 in the morning or whatever it is. And I think all my colleagues will will agree that, or most of my colleagues, the ones I've at least talked to, will say that mediations are getting done earlier in the day. And so I don't think you have to be cold and hungry and uncomfortable.
Yeah.
And so I think we make better decisions when we are comfortable. And if you're in an environment that is comfortable. So one of the things that I've recently done is instituted business casual at, in my mediations. Not necessarily, I haven't gotten there yet on my arbitrations, but I've done that in the mediations, because I'm trying more and more to delineate that this is not litigation. This is different than what litigation is. It's a different practice and different process. And how many times have you decided, Jeremy, that it's Saturday morning, I got to get up and get a bunch of work done. I'm going to go put on my most uncomfortable suit or a tuxedo.
Tuxedo.
Don't do that. That's right.
And you don't do that, right? So you put on some gym shorts and a t-shirt and some flip-flops, and you go in there and put your legs up on your desk, and you work on your laptop, and you get all your work done.
So
Sure.
all of that is a perfect segue to what I know my clients would say is the most important question that I'm going to ask you. It's probably the most important question that I have from my own perspective, because it drives me nuts. So how is it that we get mediations to be more efficient? Because all my clients, right, especially the big commercial clients, find the process, in their opinion, to be totally inefficient, because we don't have real offers till 3 o'clock. And then we go on and on and on. And then you disappear, and they don't know what you're doing.
Right.
So how do we figure this out? How do we get to a 3 o'clock offer at some much more reasonable time, so we can get this thing done and we can have real numbers being exchanged, not ridiculous numbers?
Yeah, no, I think that's part of what is exciting about the process, is trying to figure out ways to do it differently and innovate. And for me, and this is me just, I mentioned something about kind of being a workaholic and personality, is that my type of practice is not the type of practice you would typically mediate every day, but I'm pretty much mediating every day. And so out of necessity, I started thinking about, I can't keep up this pace at age 55, where, I am, I get home every night at, if you don't get to the first offer till 3 or 3:30, you don't get done till between 7 and 10 at night. Then I come home, and then I spend 3 or 4 hours getting ready for the next day. And I always read everything that's sent to me, and then I'm going to bed at 3:30 in the morning. And so then I started thinking, well, why am I doing that? And why are we waiting till 3:30? And that goes to my point earlier about, joint sessions, is we do joint sessions just because that's the way we've always done it. And 3:30 is just kind of this Pavlovian response where everybody just says, oh, okay, now's the time to get serious and get real. And if you think about kind of the process and the inefficiency of the process over the years, is traditionally at the beginning of this process in the 90s and 2000s and even now, people would come in and they put a demand on the table, and typically it's this death by 1,000 cuts of starting really high and really low.
Yeah.
And then all day, back and forth, it seems like nothing, at least to the parties, it seems like nothing is going on, but all day people are sending numbers back and forth that have no correlation whatsoever to the settlement value of the case. And I didn't think that was particularly efficient before COVID, but speaking of COVID, everyone has, I've noticed at least, a societal change where everyone's lost patience with each other. And people aren't willing to sit there and have those kind of offers that they deem insulting over and over again. And so I thought to myself, well, let's break down the process about what we're doing and let's explain to people what's really going on in the mediations. And so, I wrote a paper recently and gave a speech called 12:30 is the new 3:30, because I'm trying to get everybody to get realistic at 12:30. Now, why not 10:30? Why not 9:30?
Good question, Mr. Shipp.
Yeah. People call me up and say, John, let's just do a half day in the afternoon because nothing happens till 3:30. Assuming, and I literally turned 3 or 4 half days mediations down a week. I just refuse to do them. I do not think they're effective for the vast majority of cases. If it's a personal injury, soft tissue car wreck case or slip and fall, sure, you can do those. But on the more complex business cases or employment cases or real property, whatever it is, I think it's just hard to get it done.
Yeah.
And so I think the reason why, and when people say nothing's happening, there's a tremendous amount of stuff that's happening. It's the critical stuff that's happening that people don't think about, but it's the foundation. If you're building a house, you can't build a house without a foundation. It's literally the foundation that you're building the house on. And what's really happening, short of some sort of creative solution where you come and mow my yard and I paint the fence
Sure.
and you wash the windows. At a certain point, if we're just talking money, for example, at a certain level, what we're really doing is we're buying and selling the lawsuit. And if you don't know what you're buying and selling, there's no way to complete that transaction. If I'm offering to sell you this microphone for $1,000, $10,000 or whatever it is, and assuming you want this microphone, you probably are not just going to say deal. You're going to ask me what's so special about the microphone. Mm-hmm. What are the qualities of it? What is it? Did someone famous speak on this microphone? Is this Elvis's microphone? Whatever it is. Yeah. And is it gold plated? All those type of things. And so you're trying. You can't buy and sell the microphone until you can figure out all the qualities of it and the value of it. Mm-hmm. And it may be that this is maybe a $10,000. I don't know anything about microphones. Maybe a $10,000 microphone, or it may be a $100 microphone. But so the first part is we've got to get everybody on the same page as to what we're buying and selling before we can even determine what the settlement value of the case is. And it may seem self-evident, but every day everybody comes in and there's gaps in knowledge and not having an idea of what everybody's going to be arguing down at the courthouse. No one's going to agree. But we need to know what they're going to argue, because we're trying to handicap what we think a judge or a jury or an arbitrator may do, which then sets the value of the case. And that's the critical foundation of what's going on. People would drag that out to 3:30, and they would say, okay, take them this one, Jeremy. Take them that. Right. Take them this little piece of paper. That'll show them. Right. And then we do that over and over again. And now it just seems like gamesmanship when people do that. So you just want to get that all out. And like I said, in the goals, you want to set a goal. And so I say, let's set 2 goals. Let's set a goal of trying to get through, maybe before, maybe after, but let's get through the buying and selling by 12:30. Mm-hmm. And let's set a goal to have a successful ending to the mediation, which people sometimes are surprised to learn may involve a case where it doesn't settle. Mm-hmm. But I said, well, let's get at 3:30. Let's get to the point where we have either settled the case, or we know what could have settled the case, but we've decided we have a better alternative. Mm-hmm. Yeah. In other words, we think we can do better at trial. Sure. You're one of the 3%. Mm-hmm. I realized a long time ago that you cannot mediate drunk, stupid, and crazy. and so if that's what we're dealing with, those are the cases you got to go try. If we're just not on the same page as to what the other side is, that's what we have our system for. Yeah. And so the first part of it is, like I said, get them through the buying and selling. And the second part, which is a challenge, is getting the attorneys to buy in to maybe negotiating in a way different than what they're traditionally negotiating. It's really not that different, but they're more used to just starting really high or really low. And I'm not sure so much, that's much of a strategy, but that's just kind of the way we've done things. And in addition to being a mediator and arbitrator, I get hired as settlement counsel, which means I get hired as a professional negotiator. It's not something I do a lot, or even advertise, but sometimes, being in mediation all day, it's like a lab. I get to see what works, what doesn't work, sure. And those kind of things. And so I tell people that it's important to negotiate with context. We want to tell them where we are, where they are, and what time it is. And people will say, John, it's too early in the day. I'm afraid they'll take it the wrong way if we send that number in there. And so, when I said speaking of mediation, they'll do the number. They just don't want to do it right now.
Yeah.
And then when you explore, they say, I don't want to do it because, we need to wait till 3:30.
Yes.
Because that's what the expectation is.
Yep.
If we give our 3:30 number, they'll think that our 3:30 number is our 9:30 number.
Yep.
And that'll be disastrous.
Yes.
And I said, yeah, that would be disastrous unless you tell them,
That's what it is.
Tell 'em
yeah,
it's not
unless you tell them this is your 3:30 number. And so all you have to do is go, here's our number. Don't take it the wrong way. We're skipping steps. This is our 3:30 number, and our expectation is you should be at your 3:30 number.
Okay.
And then, or it could be anything. Here's our number, but it's 4:30. We don't have much room to go.
Exactly.
What we don't have much room to go, or is a signal that this is kind of the range we're in. One more. Here's our number. We have maybe one more move, and this means we're really at the end of negotiation, and we don't have much at all to go. I mean, this literally can get done in 2 to 5 moves. There's no magic negotiation move. If there was, I would know it.
I thought you once told me you have a bunch of Jedi mind tricks you use to get these things resolved, John.
I think I told you that I'm not a Jedi.
Oh,
I don't have that.
I forgot that. I misunderstood. My apologies.
Yes, well, if I remember correctly, you and other lawyers always think that I want me to go use those Jedi mind tricks on the other side.
Only on that side, just so we're clear.
But no one has ever contemplated that I would have used it on you or you. But unfortunately, there is no Jedi mind trick, but a good negotiator can move somebody 5, 10, on money when you're 5, 10, 15%. You move them a little bit this way, you move them a little bit this way, but that's when you're this far apart. Nobody's moving anybody when you're this far apart. A great negotiator, when you have other deal points, can, when you're determining a position is I want $10,000. Why you want $10,000 is an interest. If you can figure out what everybody's underlying interests are and what are really driving the case, then you can use that to come up with creative solutions on how to resolve cases. And that's where a great negotiator can really show their colors.
So earlier I asked you about a question that's certainly important to clients, but I think for the practitioners who are going to be in front of you and other mediators, I think what's probably more important is, what are the mistakes that you're seeing lawyers show up and make mistakes all the time. I'm sure we unfortunately it occurs, and what are the things that we could do to help you help us, right? What are the things what materials do you want? What materials are you getting? You're like, I don't want these. Like, how do we make this better for you, helping us get the case resolved?
Yeah, I mean, there are on a regular basis, I'm sending emails out the night before mediation going, do you have anything you want me to review? And a little, maybe not super excited about the idea that I'm sending this email out at 8:00 at night.
I might send you something.
Right, I don't have anything in the file. And I've literally had people send me position papers an hour into mediation and just telling me to read it at my leisure. I don't have time to go to the bathroom. I don't have time to check emails. I don't have time to make phone calls. And so people see the mediator as just sitting around not doing anything because they're not in their room. But I am, if I'm not in your room, I'm in the other room. And so I think one of the biggest things is preparation. And I think preparing, a concise, position paper that lays out the good parts and even the bad parts. I mean, that's the thing too, is that, you can assume I'm getting stuff from the other side.
Yep.
And, there's nothing that gives you more credibility with me than saying, here's all the good parts of my case, here are all the bad parts of my case. Because I'm going to hear it anyway.
Yeah.
Sure.
Yeah.
But this is a way for you to position it in the best possible light.
Sure.
And here are our damages, and most importantly, here's how we calculate our damages. And giving that in a concise position statement. I mean, 10 pages. I don't need a 50-page single-space position paper.
Sure.
I mean, what do you, if you're trying to hide something from somebody, on the other side in discovery, you've got a bad document or whatever, what do most lawyers do? They bury the other side with documents and information. Why would you bury me with documents and information when I'm trying to help you?
Yes.
And I mean, it doesn't do any good to put me in a position where I'm having to do your job for you, where oftentimes what will happen is people will just they'll just have their paralegal send me literally their entire file.
Wow.
Everything. And I don't need to see the 9 versions of an amended petition. I just need to see the last one. Unless there's a reason why I need to see, maybe these facts have changed, but you could probably put that in a position paper without just sending me, or here, read our summary judgment. Well, okay, I can read your 50-page summary judgment, but it may be a better use of my time if you had taken a little bit of time and I know we're all busy as attorneys, and I was guilty of this as well, but that also kind of, in the back of my head, I'm thinking to myself how seriously the attorney is taking these things.
Sure.
And maybe how serious the client is taking these things when I'm not getting position papers, or people aren't giving me the information that would seem to be pretty relevant to what the case is. So I think preparation is one of the biggest things that people can do. I don't see it much anymore when we talk about how things have changed, but I think when I told people that my job was not to settle their case, there's a great line in a great scene in The Fugitive with Tommy Lee Jones, a good Texas boy, went to St. Mark's, with Tommy Lee Jones and Harrison Ford, where he's got, he's trying to, Harrison Ford's escaped from jail for wrongfully convicted of killing his wife. And so Tommy Lee Jones, the U.S. Marshal, has gone to bring him back to jail, and he's got him cornered he's got Harrison Ford in a storm drain, and Harrison Ford, I think, has a gun on him, and he goes, "I didn't kill my wife," and Tommy Lee Jones says, "I don't care," because his job is not to determine innocent or guilt. His job is simply, he has one job, which is to bring you to jail. Yeah. And so my job is to put everybody in a position to bring you to a point where you decide whether you want to settle the case, not to settle it. But I think that has alleviated this issue to some extent, but some lawyers see me as the enemy, and they see me sometimes as, they somehow see me somehow as a threat, that my goals are counter to whatever their goals are. And often, I think traditionally, mediators would go in with the idea that their job is to settle this case at any cost. At a certain point, you just become a used car salesman. And it may not be in your best interest to settle a case, or have some mediator trying to manipulate you into trying to settle the case.
Yep. Yeah.
So I think realizing that my job is to help both sides. I'm a neutral, a professional neutral, but the more information you give me, the more likely I'm able to help you get to where you want to be. People kick me out of the room, for example. That doesn't bother me, but there might be times where it might actually be beneficial for you to have me in the room. Like, I literally don't care what your number is, but at least from the standpoint of where you want to end up.
Occasionally you care.
Well, no.
I've given you numbers you didn't like.
Let me take that back. I don't care what the final number is.
Right. Yeah. The first number, maybe.
I don't care what the final number is, but you're right. And that's the thing, is that I'm not a wallflower. I'll come out and I'll be pretty direct about, that's stupid. We're not doing that. And
Well, that's part of that, getting to that 330 number too, right? Because if we start too far crazy, then it's harder to get to there.
Well, right. I mean,
let's just cut through that.
And some of it is, it harms the process. It harms the process to come in and put some kind of number on the table that everybody knows is not going to do anything other than just upset things. It doesn't have any relation to anything.
Yeah.
So John, is there anything we haven't asked you today that you'd like to address?
I feel like I'm in a deposition. I feel like I'm on a trial. It's a good trial lawyer who asking these questions. I don't know. I think you guys, being the excellent lawyers you are, I think you've covered most of the bases. But I do have, let me ask you from your perspective, what are the things? What do you think the things are that mediators can do better?
Well, I find the most successful mediations I've had on significant cases that I didn't even think were necessarily going to settle, those mediators called days in advance and had calls for an hour, 2 hours with me, and they called the other side and had a call. And those calls were helpful because it made sure that the mediator was prepped for what was really going to happen when we got to mediation. And sometimes lawyers during mediation or before mediation will have a different conversation with you in that situation. And then in those calls, I can talk to them about the mediator about what opposing counsel is likely to be doing, or what they're likely to actually do, and why we can't have that go on, because that's a waste of everybody's time. This is for show, and all you can do is piss off my client, and now you're harming the process. So we can deal with some of this in advance and have everybody, and make sure the lawyers have to be prepared for that call, which means they'll be prepared for the media. It just helps make sure that the day you arrive at 9 a.m. or whatever it is, people are far more advanced than if they just show up cold.
I agree. I mean, I encourage every lawyer to reach out to the mediator and have those conversations. Guess what I'm doing on the way home?
You're talking to lawyers about mediation?
Yeah, the second conversation about this mediation that's coming up.
Yeah.
And so we're having another conversation on my drive back home. We've set up a meeting. I'm going to call the lawyer and we're going to talk about the case. And so I think that's important. And I think the preparation thing too for lawyers, when I was practicing, it was always good for me because it required me to sit down and crystallize what my case truly was. And then there would be times where I would go, oh, how am I going to prove that up? I
Exactly.
hadn't really thought that through, Now I've got to think. Now I have to think about that. How am I going to prove that damage? So I think that's beneficial to both sides.
I mean, I've been in enough mediations. I've seen all sorts of things go on, and one of them is that, look, to me, from my clients, they definitely want, and I do too, the other side to be challenged on their facts, on their law, on their damages calculations, right? And just to be clear, I expect the same. In fact, sometimes it may be that I think that's what needs to be happening, that we need to be challenged too. But I've had mediators that won't do it. They just don't. They just go along with, well, and here's a number, and here's a number. They don't do it. Then I got other mediators who will decide that they want to show up lawyers in front of their clients because they just want to have a fight with you. And honestly, I think what happens in that scenario is they've run out of things to push your client on. So now they've gone to used car sales sort of things. They want to get a settlement, and so now they got to do something. So now they're just going to argue.
Yeah, and I don't do that, and like I said, or I try not to do that. I mean, people may think I do that, but I try not to do that. But as I think we may have talked about recently, is that I've only got a couple rules in mediation. One is do no harm. I can't go in the other room and say, hey, there's this great claim that that you should make against Dunham and Jeremy's client. I can come in and tell you, hey, they haven't made this claim.
Yeah.
But and they'll probably figure it out, but it's not my job to go make their case better. So do no harm. Rule number 2 is never make the attorneys look bad in front of their client. Jeremy, you're doing a great job.
I like rule number 2.
It's a good rule. Well, listen to the rest of the rules. Rule number 3,
I know what these rules
never
are.
lose control of the mediation.
That's a good one.
And number 4 is if 3 happens, ignore rule number 2.
Okay.
That's the only time that 2 goes away.
Yeah.
That's when typically somebody is trying to hijack the mediation. And so from the standpoint of, and that's the thing is that I try to be, because, being on the other side of things, I try to be transparent with people about, okay, the pressure on me is not how to mediate the case. The pressure on me is that you're in this room by yourself, thinking nothing is going on. And so it's to accomplish what I can accomplish as quickly as possible so I can get back in your room so you recognize that. But I will check in and say, hey, this is what's going on. We're working through this and working through that. And sometimes people will say, well, are you telling them that? You told them this? You told them that? I said, yeah, 3 hours ago. Yeah. Or actually, my initial response is, no, I think they have a great case. I haven't told them anything.
All right.
Well, I feel like we could talk about this for hours with you, but I think we're about out of time.
We're-
So it's been a pleasure having you. Really.
Well, thank you. I really appreciate you having me and enjoyed it.
Thank you, John.
Thanks, guys.